Thank you, Your Honor.
All right, the next case is James R. Shoemaker, D.O. et al. Versus SONIA, SLIGER, etc. I've got 5 minutes on there. Did you want a different amount of time for rebuttal?
Well, let me ask, may it please the court, beforehand, would the court's preference be that I address the cross appeal now? And if we do, and then I won't address it in my rebuttal?
Well, if, you can do it that way if you want to.
That's fine, because it's a de novo issue, so.
Rebuttal time, so.
Then I'll take, what I'd like to ask for is 5 minutes for rebuttal.
All right.
And I'll address the main appeal points then.
Okay.
Thank you, Your Honors. May it please the court, Dinah Stein on behalf of the appellant, cross appellee, Dr. James Shoemaker. And of course, the key issue and the one that we believe renders all of the other issues academic is the one raised regarding the directed verdict. It is our position that under the view of the undisputed facts, there is no way the plaintiff can establish causation testimony against Dr. Shoemaker under Gooding. And what plaintiffs want this court to do is to look at Dr. Shoemaker's care and treatment and the expert testimony in isolation, and not look at the actual facts that occurred after that, and say, if you look at it in isolation, causation was established. And
You have to take the evidence in the light most favorable to the non-moving party, right?
Absolutely.
And you would also agree that generally, in the most cases, that causation is a fact issue for the jury to decide. You would agree with that too, wouldn't you?
I would agree with that as a legal principle, yes.
And so we have two expert witnesses, I think Dr. Brown and Dr. Bruce, if I'm pronouncing the name correctly, that basically said that post-operative care of an individual that's had heart surgery like this individual had, that presents with a fever, I think they were both consistent in saying that the first thing that you want to do is rule out the infection. I think it's a type of staph infection. But in any event, you want to rule out that specific type of infection because it can be so fatal and it can be so dangerous. And the first thing that you want to do is get the cultures taken to determine whether that infection does exist, and if the infection does exist, you have to treat it very aggressively. And they say that Dr. Shoemaker deviated from the standard of care because although Dr. Shoemaker knew about the surgery and knew that he presented with a fever, Dr. Shoemaker thought that he may have had a urinary tract infection or a lung infection, and gave antibiotics for treatment of those maladies that he thought existed, and didn't automatically rule in the infection that typically occurs in cases where the surgery occurs and the person presents with the fever. And so they said that he deviated from that standard of care, and that therefore when he gave the antibiotics, that delayed the culture process because you have to cleanse the body of the antibiotics before the cultures become accurate for reading, at least most of the times anyway. And they said that more likely than not caused his injuries and his subsequent death. And so I have a difficult time understanding, based on that testimony and taking it in the light most favorable to the non-moving party, why the trial court should have granted a directed verdict in this case.
Okay, and for the purposes of this appeal, we've accepted that testimony. Okay. And had certainly, had that been the only testimony and facts, I think this would be a situation where there's no directed verdict entitlement. Our point being that we can't ignore what happened. And what happened is that, notwithstanding anything Dr. Shoemaker did or did not do, Mr. SLIGER did present to the hospital 5 days after he saw Dr. Shoemaker. One thing that's undisputed by the plaintiffs and defense experts is that when he presented to Dr. Tello, the infectious disease physician, he was still treatable. So that's one thing.
He was salvageable.
He was salvageable.
Possibly treatable, and Dr. Tello said that, yes, I see that we have a patient here that's had this surgery, and my first concern is the infection. But Dr. Tello said, I don't want to give him this one particular antibiotic because I was concerned about his liver problems. And so essentially what happened is Dr. Shoemaker, there's evidence that Dr. Shoemaker deviated from the standard of care, and that may have contributed or likely caused his death, and then so did Dr. Tello. But the problem is the jury found that there was no negligence on the part of Dr. Tello, right?
That's correct.
And the jury has the right to do that, but that doesn't necessarily mean or relieve Dr. Shoemaker of his negligence, does it?
Only if there's something in the record to show that there was a causal connection. And let me go back to what, if I may.
Here's what's bothering me about the causal connection, because the experts testified, or at least one of them, that the die was cast when he gave them the antibiotics and the cultures weren't done, and the die was cast and that was it, and that's what did it. And so that was one of the key points of at least one, I think probably both of those experts' opinions, but at least one of them said that. And said after that the die was cast, and that was the point where it became too late.
Your Honor, if I may, first let me address the die, because the die that was cast that the plaintiff's experts said was he should have been given rifampin. That was the die, that had he been given rifampin, it would have penetrated the bacterial infection in the valve and been the elixir for his treatment. So that's very important, because that was what the plaintiff said caused.
If Shoemaker done that and not deviated from the standard of care, then it seemed to indicate that would have indicated the path to the other doctors that they were to follow.
But see,
and when Dr. Tello saw that had not been done, and then Dr. Tello became concerned about his liver problems, then he didn't give him that one particular drug.
Correctly so, too, according to the jury.
Had Dr. Shoemaker done that from the beginning?
Well, first of all, let me make a point of that. There was no testimony that Dr. Shoemaker should have administered the rifampin. In other words, they all agreed that he should have referred Mr. Sliger to someone. The two doctors testified that if he did not know what to do, he should have referred him to a surgeon. But that's correct.
Dr. Shoemaker testified that I've treated other patients that have had this surgery and presented with fever. So I knew that one of the things I needed to look out for was this particular infection. And instead, I treated him for a urinary infection and for a lung infection, and didn't give him the antibiotics that were the appropriate protocol to treat that particular type of infection. And so he knew that.
We are not here to take issue with the testimony regarding standard of care.
Okay. We're talking about causation.
We're talking about causation.
Care likely contribute to this man's death, and I'm having a difficult time.
Then please, I want to take the court there. I appreciate that, Your Honor. Okay, again, rifampin is key here, because that is what the plaintiff's experts said wasn't done and which contributed to the death. So then we get to the infectious disease physician who plaintiffs say he should have been referred to. It happened. We don't have to speculate as to what would have happened, because it happened. Dr. Tello got on the stand as a defendant and said, I made a conscious medical decision as an infectious disease physician not to give the plaintiff rifampin. So he has now said, and the plaintiffs contended that was negligent. The jury found that was proper. Now let's take the plaintiff's argument.
No, hold on a second. I'm sorry, I got to disagree with you on that. Did you have an interrogatory verdict here?
We have.
Did they say that Dr. Tello didn't?
I understand what you're asking. In other words, whether he was negligent or causal?
Right. I mean, they could have found that he wasn't the cause of the death, right?
I disagree, because
they could have accepted the plaintiff's expert's testimony And they could have disregarded the whole or any part of Dr. Tello's testimony, right?
I disagree because of this, because
Well, answer my question, though. Did you have...
there was no interrogatory verdict.
Okay.
No, it was a Fabre, not Fabre, because he was a defendant, it was an apportionment verdict.
Standard verdict, right?
That was a standard verdict form. There were two other defendants in this case who were at trial and defended themselves, and that is the cardiologists, Dr. Weaver and Dr. Lanza. They were also found to be at fault. They were rendered 60% at fault in not treating him sooner and not intervening sooner and being a direct cause, a causal agent in the death. So had Dr. Tello been the last, had this been Dr. Shoemaker as the one doing it, then Dr. Tello had to have been found not negligent, because if he was not a cause, the surgeons then can't become a cause again. Now, they didn't appeal that. They chose to resolve that after the verdict, but that's law of the case now. So again, we can't just look at Dr. SLIGER in isolation. We can't look at Dr. Tello in isolation.
Argument is that this court, as a matter of law, has to accept the proposition that the jury accepted all of Dr. Tello's testimony. And I don't understand how you can make that argument. The jury could have disregarded his entire testimony and still determined that they didn't want to find him negligent in the case. I mean, the jury's got the entire, they don't have to necessarily be consistent, and we really can't speculate as to what their reasons were, right?
Respectfully, I'd submit that the jury does have to be consistent. I think the jury has to render a verdict that makes sense.
Just because they say that one party is, and we're basically talking about comparative negligence here anyway, just because one party we're going to assign 0 to in terms of liability, that doesn't necessarily relieve the other parties of their liability. And it seems to me that the jury could have very well thought that the testimony from Brown and Bruce that indicated that this set in motion a treatment protocol set by Dr. Shoemaker that essentially made it more difficult for the subsequent doctors to get the cultures and to subsequently treat. Dr. Tello said that, well, what Dr. Shoemaker did really wouldn't have affected, my diagnosis in treatment, but the jury could have disregarded that too, and just gone with the testimony that the die was cast when he didn't take the cultures and when he gave these antibiotics that he shouldn't have given, and when he didn't look directly at the infection as the number one culprit that he should have looked at first rather than these other infections.
Well, the jury still had to look at what Dr. Tello did. I mean, this isn't something that Dr. Tello was saying as an afterthought. This was in his medical records is why he made his decisions.
I'll be honest with you and tell you that it struck me as very strange that the jury did what they did in this case. I mean, how Dr. Tello could have said, well, Dr. Shoemaker didn't, what he did didn't affect my decisions in the case, and then Dr. Tello doesn't give him the one antibiotic drug, but maybe the jury thought that by that time it was too late.
Well, let me make another point on that, because I have already made the point of the cardiologists,
right.
Because my position is it's impossible to cut it off at Dr. Tello and then find them negligent. The other thing is that what the plaintiffs are saying, and I think Your Honor is suggesting, is that the jury can disregard certain expert testimony, and I would say that it can't disregard expert testimony that's undisputed.
What I'm saying is that in determining whether a directed verdict should be granted, especially on causation issues that are typically fact issues for the jury to resolve, and you take the evidence in the light most favorable to the non-moving party, and that's what I'm looking at in this case, taking the evidence in the light most favorable to the non-moving party. And what was the trial judge supposed to do, given the testimony of Brown and Bruce, and that to me was pretty clear.
Well, I go back to, and
So you can't, the trial court can't disregard that either. And so taking the evidence in the light most, and if there's conflicting testimony or there's, credibility issues, the jury's supposed to resolve all that.
if there's a conflict, and we are not contending there's a conflict, the law we're relying on is from the Posner case, from the Harris case, which says that the opinion of an expert can't constitute the operative facts. The opinion of an expert still has to be based on the facts. And that is exactly what, and I'd say the closest case to this is Posner from the 3rd District, where it was a very similar expert testimony situation. The expert gave 6 different theories of negligence against the defendant doctor and said, had he only done this...
But I don't think you objected to the experts' opinions coming in.
That is, and I disagree that that's an issue. No, we didn't object, and this isn't about sufficiency, or this isn't about admissibility.
Opinions that came in, and the trial court's supposed to deal with them and take the evidence in the light most favorable to the non-moving party. Yeah.
And occasionally, a plaintiff puts on all their evidence and doesn't meet their burden. Occasionally, that happens, and it happened here.
Their burden with the testimony of these 2 expert witnesses?
In isolation, perhaps, based on the facts, absolutely not. And I strongly take that position. We have to look at the facts and the jury's finding. We can't ignore that and look at everyone independently. And this is one of those perhaps less common situations, but they happen. We've cited a number of cases.
It's a strange verdict.
It's an absolutely strange verdict, and we took the position below that even the verdict alone can't be...
Just because it's strange, though, doesn't necessarily...
No, because it's internally inconsistent, based on the undisputed facts. We took the position it was beyond strange. This is my time for the cross appeal, so I'd like to just address some of that, because obviously, and we'll have to just rest on the briefs for the other issues because of time. Obviously, this...
Another extra 3 minutes. I'm going to give you an extra 3 minutes, so you can count on that.
Okay, I appreciate that.
All right.
Then as to the constitutionality of the caps, which I presume you want me to address.
Would you address the net accumulations issue? And because I think Dr. Raffa gave one figure and the jury kind of exceeded that a little bit. Was that, you didn't want to address that?
I wanted to address the other points first. They were a priority, and I don't want to ignore, I mean, obviously, we raised all points that we thought were worth raising, but I just think there's some...
So you think that the constitutionality of the statute setting the caps is an important issue to you?
I don't think it should be in this case, but obviously...
I want to discuss it, so go ahead. I mean, go
well, I'm going to, since I've got the extra time, I'm going to start with, because we did bring the argument about interpretation of the cap statute first, vis-a-vis, because we also have the settlement proposal issue, and I'll be brief, but I'll make our point. We have a settlement proposal statute and law which requires apportionments, and you have to apportion per every single party, and so forth, so that the offeree can make an informed decision. And the court took the position here, and of course the First District has taken this position, that when it comes to an estate, even though statutory survivors are real parties in interest, they don't have to be separated. And just to point out the fundamental unfairness of that, many times, as in this case, the statutory survivors have very different claims for damages. And we submit the offeree, and a personal representative has the legal right to settle on behalf of less than all statutory survivors. So we submit that...
The court has a say in that, too. Doesn't the court have a say in, you know, when an estate gets an award for damages, the personal representative can say, Judge, this is how I think it should be doled out amongst the claimants, but the trial court has a say in that too, doesn't it?
If someone objects, or if there's a minor, then the court does have a say in it, but I don't think that makes it...
Okay, well, what is the main point that you want to make on that issue?
The main point we want to make is we believe that the First District in Thompson is incorrect, and that the statutory survivors under the settlement proposal rule are real parties in interest, and when a settlement proposal is made, or by or to the personal representative, it must be apportioned by statutory survivors so that the offeree, the defendant, can choose to take out perhaps one of the more vulnerable or one of the easier claims to resolve. And what makes it so unfair in situations such as this is that here, again going back to the fact that many times there are very disparate claims, the defendant looking at a proposal has to look at it as a lump sum under the court's ruling, and it all goes into the same pot when deciding whether or not the proposal was hit. What the position we additionally took as to that, which...
I honestly don't see a problem with that. I don't think that that's unfair.
Well, part of the unfairness is the way, because then we have the way the cap statute was applied here, where we said if the personal representative is the only one party in interest for the settlement proposal statute, then make that same interpretation as to the aggregation of the cap. So I'll move on to the constitutional arguments, which again, we don't think are, should be addressed here, but understanding that there are different positions. Obviously, this issue is pending right now in the Supreme Court. I submit that the Supreme Court's decision, whatever it may be, may or may not be binding, but here we do also have a wrongful death action like in McCall. But just to go through some of the points that the plaintiffs have raised in case the court wants to independently address it, it's our position that most of these points have been, these constitutional arguments have been dealt with already by the Supreme Court and rejected. In University of Miami versus Asharte, that was dealing with tort reform caps, and the Supreme Court rejected almost all of the same types of constitutional challenges that the plaintiffs have made here. I believe due process, separation of powers, equal protection. The only thing it addressed is access to courts, because that is done on a case-by-case basis, applying the Kluger two-part test. And of course, the Kluger two-part test is if you're taking away a right, then you have to show that the legislature either had an overpowering need to enact the legislation, or that it had no alternative method of doing so. And here, and we've cited to the materials and so forth, the legislature, in fact, the governor had created a select task force to deal with this prior to the legislation being enacted in 2003, which involved numerous hearings, studies, acceptance of evidence from the medical profession, the insurance industry, the legal profession, victims of malpractice, conducted numerous hearings dealing with what it perceived as a very critical crisis in the medical healthcare industry, with doctors leaving, unable to get insurance, not wanting to practice in Florida, and so forth. And so in enacting the cap statute, the legislature didn't do it in a vacuum. They rendered very detailed findings of why this type of limitation on non-economic damages is necessary, and why it had no alternative means of doing so. So if we look to the Kluger two-part test, it passed in Asharte, and it passes here. And this is not a situation like the Smith versus Florida Insurance, where there were no legislative findings, and the court said that just doesn't pass the Kluger test. Now, as far as some of the...
Are you going to exhaust all your rebuttal time, the extra time too, because you're almost...
So what I have now is for rebuttal?
You see that?
Yes.
You're into your extra time.
No, then Your Honor, the answer is no, I'm not. I will reserve the rest of my time for rebuttal.
I'll give you 1 minute for rebuttal.
I appreciate the extra time, Your Honor.
All righty. And given that she addressed the cross appeal, did you want rebuttal time on the cross appeal?
I would, Your Honor. I think in view...
I'm only gonna let you have rebuttal as to whatever she says when she gets back up here.
Yes, Your
I'm
Honor.
not gonna let you go into all the other issues, okay?
I hope the court's perception is that the parties properly divided those things up in the briefs, and
sir.
I will do that.
All right. How much rebuttal time you want?
I think 3 minutes will be adequate under the circumstances. Thank you, Your Honor. And good morning, and may it please the court. I'm David Sales for the personal representative. With me today is Steve Knox of Morgan & Morgan, who was trial counsel in this case. What I'd like to do, Your Honor, is talk a little bit about the directed verdict issue first. Yes.
What about the fact that Dr. Tello testified that Dr. Shoemaker did really didn't affect, his diagnosis, his and the jury found that he wasn't responsible or liable.
Yes, Your Honor.
And he was the one, and yet there was testimony that Mr. Sliger was salvageable when he went into the hospital and still could have been treated, and yet Dr. Tello testified, well, what Dr. Shoemaker did really didn't matter.
As an overview in response to that, and I have a direct response to Your Honor's question.
I mean, it's kind of strange. It's kind of a strange verdict to me, but in any event.
We think not, Your Honor. No, I can explain that, if I may, Your Honor.
Okay, go ahead.
It's important to remember, I think, as an overview, broad overview, that in this case, the question was time. This was an infection case, and the overwhelming evidence, certainly in the light most favorable to the plaintiff, was that time was Mr. Sliger's enemy. And we know from pathological examination by the surgeon that the junk that needed to be fought with the antibiotic that was never given was what killed this man. And the longer it sat there without the proper antibiotic, the more the difference, the more the difference is rendered. Now, getting to the question of why the verdict makes sense, and of course, I would just point out to the court, and respectfully, Your Honor, think of all the energy that's being applied in this particular appeal to try and figure out why the jury did what it did, when, as Your Honor framed the question to Ms. Stein, the question is, was there evidence to support the jury's verdict? They have no case to suggest that the court is obliged to reweigh the evidence, which we know is prohibited by the Supreme Court in the Fetterman case that came out last week, or the week before.
It was prohibited a long time before that.
Right. Yes, of course, Your Honor. But the point simply is this, and Mr. Knox and I spent a good bit of time yesterday and in the past talking about this. What are the reasons that the jury could have exonerated Dr. Tello? Judge Torpy was exactly right, because this was not a special interrogatory verdict. It comes right out of the standard model verdict form questions. Was there negligence on the part of Dr. Tello, which was a legal cause of the death of Stephen Sliger? Could the jury have found that counsel's brief says that means, ipso facto, the jury found Dr. Tello to be non-negligent? That is not what the verdict says. What the verdict says, if anything in this regard, is that he was either not negligent or he was negligent and his negligence was not a legal cause of death.
Let me ask you this. Apparently opposing counsel didn't want to address the net accumulations issue. Do you want to talk about that?
I have plenty of time to do that, but I would like to address Your Honor's questions about whether or not this verdict is strange or not. First of all, if you confine yourselves respectfully to the direct testimony of Dr. Bruce from page 1647 to 1694.
I understand all that. I see Dr. Brown and Dr. Bruce basically saying the same thing.
Right.
And my thought is it would have been very difficult for the trial court to have granted a directed verdict. It should have gone to the jury, and the jury should have decided the issue. But it is also, it is kind of strange to me that Dr. Shoemaker is being accused of violating the standard of care by not giving these antibiotic drugs. There is testimony that Mr. Sliger was salvageable when he went into the hospital, and Dr. Tello basically did the same thing that Dr. Shoemaker did in withholding the one drug. But Dr. Tello had an excuse saying that I was concerned about his liver. I knew about the protocol. I knew what to do. I didn't give him this one drug because of his liver. And it seems to me that there may have been some conflicting testimony as to whether that drug, would have been absolutely necessary, but it seems to me that that would have been an important drug to give Mr. Sliger.
There are a couple of things. First of all, Dr. Tello actually administered rifampin. He did it briefly.
But took him off.
He did take him off. There are other reasons for which the jury could have exonerated Dr. Tello, if that's the standard to which we're going to be put in this case, and we submit that it should be. That's one reason. Another reason, which appears at page 1744 of the transcript, when defense counsel was cross-examining Dr. Bruch, he receded slightly from his opinion about salvageability. The question was asked, if he had received what you considered standard of care medicine and received rifampin, do you still believe that Mr. Sliger would have survived? Yes, I do. And you believe that is true when he arrived at the hospital on the 18th, regardless of anything Dr. Shoemaker did or didn't do? And he said, probably so. And counsel went right back and said, in your deposition, you said definitely. The jury had a reason to discredit Dr. Bruch with respect to that aspect of his testimony. And in light of the other evidence that time was Mr. Sliger's enemy, it was reasonable for the jury to do so. We're talking about 5 days of no medication that was necessary to keep this man from dying. And in addition to that, Dr. Tello testified. One of the things that we were accusing the cardiologist of the case of was failing to monitor Mr. Sliger's cardiac health sufficiently while he was hospitalized. Dr. Tello testified, I told Mr. Sliger, you're going to have that valve come out. He was among the people in the hospital who...
Also told him there was no time rush on it either, which I thought was kind of unusual, but...
He did, but the jury could have reasonably believed in that setting that it was reasonable for Dr. Tello not to be found a cause because he was among the first people to say that heart surgery was required. It was delayed a few more days. We argued as a result of the co-defendant's negligence, the cardiologist, and that certainly the jury could have found as well. So we do not agree, most respectfully, Judge Soraya, that this is, as you put it, a strange verdict. In any event, going back to where we started, the question is, was there evidence to support the jury's verdict? And as I mentioned previously, if the court confines itself only to the direct examination of Dr. Bruch and nothing else, what we say, the failure to give the life-sparing drug, it was standard of care for Dr. Shoemaker. He didn't do it, and that is viewed in the light most favorable to the plaintiff. And
I don't have any more questions on causation, so if you want to move on, unless the other two...
I think the issue on the net accumulations is, you know, we state it fairly clearly with respect to the standard jury instructions and the way the trial judge analyzed the issue, because we made the same argument in the trial court that we made here. And as Your Honor may recall, Judge Kest said, you know, Dr. Raffa did a good job of explaining to the jury the way these things work. And one of the ingredients and elements of his economic testimony was the reliance upon standard tables and data with respect to what rate people save at. This jury had some information.
The jury could have come up with something different,
Right.
and I understand that. But it's just, you know, Dr. Raffa came up with one figure, and the jury came up with one that was a little bit higher, although when you average it out...
Again, we are after the fact, essentially being asked to reweigh the evidence, and Your Honors are as well. Is there any way, and usually when we're in this circumstance, there's a question about whether...
The opposing counsel didn't seem to think that the issue was important enough to discuss.
Well, I'm addressing because it seemed like it might be important to Your Honor. And the question... The question, as far as we're concerned, Your Honor, is whether there was substantial competent evidence to support the verdict, and the jury was free, as we indicate in the brief, to take what Dr. Raffa said would be support and services, say that he was not likely to give that type of support, rather, to his wife and children, and instead was likely to commit that to savings. And moreover, I think the theme of my argument in my brief is that Dr. Raffa, as the court perhaps observed, took a conservative approach. He took a low-income figure. He took a figure that assumed a low growth rate for Mr. Sliger's...
the jury could have assumed a higher growth rate.
I think your argument as to causation, that you just take the direct testimony, is awfully simplistic.
Yes, sir.
You know, I mean, you've got, you know, the cross-examination. I think you look at the totality of the circumstances.
If you take the cross-examination of Dr. Bruch, and I think it's at pages 1744 and 50, as I recall, he reiterates what he said in direct examination, that the failure to give rifampin was a but-for cause of the death, and had Dr. Shoemaker, by implication, given it, which he testified on direct examination was the standard of care. I think it's important to remember in that regard, if we're talking about the entire context of the testimony, Judge Cohen, is that Dr. Bruch is not only a professor at the Harvard Medical School, but he's a leading authority, as the record suggests, on infective endocarditis. And he is, even though he is called an infectious disease doctor, because of the way they are trained as internists first and then become infectious disease physicians. And he specifically said, I am here, I am qualified to talk about the standard of care applicable to Dr. Shoemaker, and he identified those specific breaches. I think the question, again, is we are not asking the court to limit itself only to Dr. Bruch's direct testimony. My argument simply was, if the court did only that, since the question is there substantial competent evidence to support the jury verdict, is there any basis upon which this jury could have concluded that Dr. Shoemaker was negligent, and his negligence was a but-for cause of Mr. Sliger's death, and the evidence, when it's all combined, directs and crosses of both experts, and not leaving out, most importantly, the testimony and the records of the treating surgeon who identified the very thing that should have been feared as the cause of death, something that would not, the evidence suggests, have occurred if Dr. Shoemaker had started with the right course. The other thing, in response to this issue about Goolsbee, which is not raised at all, so far at least, by counsel, this court has said that when a subsequent doctor, often a co-defendant, as was the case here, and often there are joint defense arrangements about which the plaintiff has no knowledge, when a co-defendant sued in a case where the first defendant in time is accused of negligence, when a co-defendant comes in, there is no law that requires this court, and in fact it's the opposite under the Goolsbee decision, to accept the testimony of Dr. Tello. The jury was not only free to disregard that testimony, this court in the Goolsbee case suggests that the court is not obliged to even consider that as part of the record that would defeat the right to a jury verdict in a setting such as this. I did want to address, because I'm going to be trying to be careful, Your Honor, as Your Honor indicated, the issue of the applicable cap. Our point in that regard is simply this, that the statute, which is 766.118, and I'm going to defer my principal argument, well, my rebuttal argument, let's see, how do we do this? Okay, I think I can talk about both, but when I respond, I can only talk about counsel's response. I think I've got it. So there are two issues.
For 3 minutes, too.
Right.
Which I didn't credit you yet, so you can either have that now or during your rebuttal, so.
There are two, thank you, Your Honor. There are two issues then. One is on the main appeal. Did Judge Kest apply the correct cap? As we noted in our brief, originally, assuming it's constitutional, the defendants and the plaintiff argued for the same cap, the $1 million cap. There are two caps under the statute, 766.118. Is it the most elegant piece of law ever written? I think the lawyers in this case, everybody who's dealt with this would say no, that it's not. But what it is clear is that there are two caps, a $500,000 cap and a $1 million cap. They apply necessarily in two different circumstances, and I think that's suggested by the statute. The important language for us that I would urge the court to consider is the very first word of subsection, let me make sure I get it right, subsection 2B, which tells the reader, 766.118.
Okay.
And what it tells the reader is that notwithstanding paragraph A, and that must be sub 2A, 2 sub A in the same statute, if there's permanent vegetative state or death, the total non-economic damages recoverable from all practitioners, regardless of the claimants, shall not exceed $1 million. And counsel says, well, we argued that in order for that to ever become available, there must be some circumstance where there are multiple claimants. They have their argument, which has been addressed briefly. We disagree with that for the reasons that were stated. The claimants for non-economic damages in this case were not the estate. The estate's right of recovery is defined by statute. The claimants for non-economic damages are also defined by statute, although the word claimant isn't used. only survivors, children, parents, and...
I agree with that, but your argument is that because there was a death, it applies anyway, right?
That's right. That's our argument. And then the court is faced candidly with the question, what do we do with the language wrongful death? It appears in the first line in the version I'm looking at of subsection 2A. And the only way to make sense of it, we say, is to read the words notwithstanding paragraph A in the next section and suggest that the legislature meant what it said when it said there would be $1 million cap. Their response to that is because I say if they're right...
You didn't argue below that the only reason you thought the $1 million applied is because there are multiple claimants, didn't you? I mean, didn't you argue both to the trial court that there was a death? Or if you want to look at it the other way, there are multiple claimants because the estate is not the only party entitled to damages here.
Well, we argued two...
You argued it both, didn't you?
We argued that under the facts of this case, where there's death, there is $1 million cap, and we argued that we did not argue...
There really are multiple claimants.
We did not argue that there were three $1 million caps on economic damages, right?
Yeah.
We argued that there was a single cap. I'd like to turn then to the issue of constitutionality, and I want to focus on a single issue, because I think that with respect to that, the court need not wait for the McCall decision. We mentioned in one of the briefs, I think it's the last one, that it was argued before the Supreme Court. McCall it's a death case, as counsel indicates. It was argued before the Supreme Court in February of 2012, as I recall, and some of us, even with the Supreme Court's pace, which is usually a little bit slower than Your Honor's court, respectfully, some of us thought it would be out by now. Could come out today, I expect.
A little bit slower.
It is a little bit slower.
I wouldn't think it said it's a lot slower.
But the court need not wait, we believe, because of the Philippe decision. And if the court confines itself, which I believe that the court can do, decide the issues of constitutionality on a single ground, and that would be equal protection. What the Philippe case tells us, counsel says it's only dicta, but it cannot be for the reasons given in our brief. Philippe tells us that if the legislature makes available the same basket of money, in this case we say $1 million, for a surviving spouse and multiple children, as it would for a surviving spouse and a single child, that does not satisfy the constitutional tests of rational basis, and that it works a fundamental injustice, or it is not consistent with fundamental justice. It's right on the face of the decision, and the only way around it for counsel in this particular case, the only way around Philippe is twofold. One, to say that, well, that was arbitration and this is lawsuits, and that's a distinction without a difference, because the legislature is talking about types of claimants, and the only other way to deal with it is their argument that it is dicta. But for the reasons we set forth in our reply brief on the cross appeal, it could not have been dicta, because if the Supreme Court in Philippe had concluded that this was an aggregate cap, now in our case, 766.118, the statute is crystal clear. It's an aggregate cap. It says regardless of the number of claimants, and it says regardless of the number of practitioners. You are capped on the face of the statute regardless of how many people are hurt. And under Philippe, that issue was not presented that way, because the court did not read the statute as providing for an aggregate cap. There's no way to escape that, and in this particular case, that is a denial of equal protection for the reasons that are stated, and I see I'm down to 1:46:45, which I'd like to save. Thank you.
Okay, well, you got more than that, because I didn't give you your 3 yet, Mr. Sales, so...
All right, thank you, Your Honor.
I'll to you in a rebuttal if you need it.
Thank you, Your Honor.
All right. Just a second, let me set the clock here so that we're,
Am I correct that Mr. Sales is also getting a rebuttal, so I could address?
He's going to get a rebuttal as to anything that you talk about right now,
Okay.
as it pertains to the cross appeal. Yeah.
Okay,
If you talk about the cross appeal, he's going to get a rebuttal as to...
Okay, I'm going to start with, since I would normally get a rebuttal on the main appeal with that, and I'll pick up with something that my opposing counsel brought up, and that is the Goolsby, Munoz-type decisions, because he's suggesting that this falls in that, and I think this is important, because that was the position that was taken below. And what those decisions stand for is that if you're a defendant medical provider who is accused of negligently failing to diagnose or warn, and as a result cause injury to a patient, you can't defend yourself by saying, even if I was negligent, no one would have listened to me, and that cuts off causation. You can't do that. If you were negligent and you caused someone not to be treated, you can't defend yourself on causation by saying, no one would have listened to me, or the plaintiff didn't prove that someone would have listened to me. The difference here is that we don't need to speculate as to what happened, and that is a huge difference. If this was just a situation where Dr. SHOEMAKER had treated Mr. SLIGER and he never got subsequent help, we'd be in Goolsby, and we'd be in Munoz. But that's not these facts. And here, we don't need to speculate because we have Dr. Tello's medical records, and we know what happened, and we know that he didn't do anything different because of anything Dr. SHOEMAKER did. He testified to that, and he said, my medical records say the same thing. I wrote in my medical records, I want to give rifampin, I can't and I won't, other than the brief periods he did that. So that's what takes this case out of Goolsby and into Harris and into
I'm going to ask you
Posner.
to close on that thought, because...
Okay, and I appreciate the extra time, Your Honors,
Yeah,
and...
gave a lot of extra time.
Okay, thank you, Your Honors.
All right, and she didn't really address the cross-appeal, Mr. Sales, so...
I think, based on the rules set by the court, I think I don't have...
Okay, sir, thank you. All right. All right, we'll take a short break here.